Good day, my name is Martin Schweiger and I will today walk you through lesson 7 of our introductory course on intellectual property for companies. The lesson 7 deals with why companies need IP or not. This lesson is for nerds and for non-nerds. I hear this question dozens of times per year. Do I need IP for my product or not? And very often I get the face like that together with a question. Ultimately, we deal with a Hobson's choice problem. Do you prefer cholera or plague? Short answer. IP is not compulsory. It is not required by law that you have a patent, a trademark, or any other IP in order to sell your products. There is no legal obligation that you can sell a product only when it is IP protected. Most people think about IP as a sword, and I've put an antique dagger here so that you can better remember what I want to say. And this is true. IP can be a sword, but that's not the point. When it comes to problems with IP, in most cases, companies stumble over IP of their competitors. Therefore, nothing beats a freedom to operate, a freedom for a company to do what it wants to do. Now, what is freedom to operate? And in order to explain freedom to operate, I like to use a photo. The people on the photo play a motivational game which is called Minefield. A person here, the person in the midst, is blindfolded, so he cannot see where he steps, and there's a simulation of landmines here, and the landmines are little balls made from duct tape, and they are placed on the floor in front of a pathway, and this person has to walk through the minefield. There's another person here, it's one of the other team members, and the team, by directing the player here, would guide him through the minefield without stepping on a mine. The same applies to a freedom to operate study. You need an expert who can discern what is a dangerous IP. Here I have marked it with a red IP button, and what is a non-dangerous IP, which is blue here. The IP expert here would tell your company what can be done and what cannot be done. The reason being, you may not be allowed to do what you want because your competition has acquired IP. A freedom to operate study is not an easy task. You would find a whole series of courses on freedom to operate study on my webpage, www.iplawyertools.com. Please check it out if you're interested in that. But let's continue on with our question. Do companies really need IP? There's a long answer to that. It depends. Very likely you will need IP. Only if you can survive on your own, without third parties' capital, you may be able to live without IP. But still, you may prefer to have IP protection in place over going unprotected. But that is your own choice. Please note that we have an entirely different situation when professional investors need to come in. So now, yes or no, I give you some examples and explain why this company needs IP or not. I often hear this. Patents can increase the chances that a company will be acquired. The answer is yes. That's very true. The main reason why professional investors want to have patents in place before they invest into a company is to make sure that the inventors don't run away and open a similar business right next door after the investment has been made. Next, patents can help a company to get ready for an IPO. And whenever you say the word IPO, you would see eyes wide open. IPO means immediate profit only. No, this is only a joke. It means initial public offering before a company goes public on a stock market. But it's always with big money. And yes, institutional investors would buy shares of a company only after having done a due diligence, of which an IP due diligence part is a compulsory part. An IPO of a company with a bad IP situation would receive a very bad rating, so that conservative financial service providers would rather not engage into such activities. This would result in a low IPO price. Next one. Patents can help startups to form joint ventures and R&D partnerships. Yes or no? Yes, this is very true. Without a patent application in place, it is very difficult to share technical information with other companies, even if an NDA is in place. A patent application lets you sleep well. So, patents as a marketing support, yes or no? Yes, market share is only gained through clients who are willing to put money on the table. In order to find them, marketing activities are needed. Patent and registered design protection should be used to safeguard early marketing activities of an invention. This would protect you from being copied from your competition. Next one. IP is an indispensable catalyst for franchising. Yes, IP protects your franchising information from being put into the public domain upon being handed over to third parties. That is very relevant. Please note that the franchisee, after having signed the franchise agreement, usually has sleepless nights until he finds out how to escape from the franchise agreement. Of course, he would escape without stopping to run his franchise business. In other words, he doesn't want to pay the franchise fee. Therefore, there is a rule: never start a franchise business without having protected it properly. Now, what is not a valid reason to have IP protection? Sometimes I hear other reasons why startups or companies need IP, but most of the time I hear utter nonsense. Patents can help a company to defend itself against attacks by rivals. What a nonsense. Please repeat after me. A patent is a sword and not a shield. Next one. Patents can help a company to stop the theft of its innovations by larger rivals. No, only if the startup or the company can afford that lawsuit, yes. Otherwise, which is the normal case, no, it won't. But don't worry and don't underestimate the not invented here attitude of your competitors. They won't copy you easily. Next one. Patents can ensure a company's freedom to operate. Repeat after me. No, a patent is in the first place a sword and not a shield. It does not provide a freedom to operate. Sometimes, but rarely, a patent can be used to generate a deadlock situation with a competitor, and this can be equivalent to a freedom to operate. But again, that's so seldom that it never happens. Next one. Companies with intellectual property achieve greater long-term success than companies without it. Firms without patent protection are much less likely to survive. No, that's not true. Most companies do not have active IP, except maybe a trademark. Next one. Patents can help a company to launch a billion-dollar empire. Wrong logic. Billion-dollar empires have patents, indeed, that is true. But most patent owners are not billion-dollar empires. So how does this look like in practice, and what can we do about it? Please check out the courses section on my webpage, www.iplawyertools.com. Please note, there's a membership, and all course fees come with a 1 month 100%, no question asked, money back guarantee. So please check it out. There's some free material there, there's some material there for members, and there are also large courses which come with a course fee. The risk is on me. I reimburse the money if you are not happy with it. My name is Martin Schweiger, and I've just walked you through lesson 7 of our IP Bootcamp course. Goodbye.